for today.
Okay, sir. Okay, sir.
Okay, okay.
So good evening to all. So today we have to discuss the topic patent in new areas. So basically, before yesterday and the day before yesterday, we are dealing with the Paris Convention, Patent Cooperation Treaty, Patent Law Treaty, World Intellectual Property Organization, as well as the TRIPS Agreement, which was deals with the international mechanism, which will strengthen to the not to infringement the intellectual property rights. So today, what are the new areas which are currently developing and in future it will be more development requires. So those areas are patent and biotechnology, patenting in genetic resources, and patenting in computer technology. So what is biotechnology? So biotechnology is one of the most talked topics in the recent year. There are two issues with regarding to biotechnology industry, two controversy issues. One is patentability. One is patentability. The patentability of the biotechnology products due to the novelty and innovative step. And the second one is ethical issue, such as who is the owner of that resources. So these two controversy issues were with the biotechnology. Who are the main stakeholders in the these uh, protection of biotechnology? So biotechnology means the technology by using to exploit the natural resources. So for that, there are three main stakeholders are there. One is commercial users, and the second one is traditional users, and the third one is academic users. So who are commercial users? The commercial users are those users who use genetic resources for the um, industrial development. For example, pharmaceutical industry. So those comes under commercial users. So um, what about the traditional users? So the traditional users, these are nothing but indigenous communities which they are, even though they are not having right to the right have to protection of their intellectual property, there is no identification, there is no recognition with regarding to the intellectual property of them, but they are their rights will be somewhere we have to control. So that is, those are called as traditional users. Here in these traditional users, each community develop its own know-how and practices regarding use of natural resources, which are passed on from generation to generations through the efforts of the traditional elders. The same know-how can be developed by the traditional users of the different communities also. So in such cases, even the legal instruments would be facing conflict in establishing who is the ownership in such type of know-how traditions. Next, the third one is academic users. The academic users are seeks to access the natural resources for varied purposes. Some of them may be used closely associated with commercial use and applied scientific research. So academic, the academic users are nothing but the people who are having access to natural resources for varied purposes. So what is the definition of Invention. So first of all, you have to understand what is the definition of invention. Before granting a patent to any invention, it is expected that it qualifies to be invention and not mere discovery of already existing things. So with regarding to Paris Convention, because that is the first convention which was uh, formed to protect the intellectual property rights. Based on the Paris Convention, does not expressly spell the definition of the invention, but it specifies the broader scope of industrial property. It states that the industrial property not only applies to industry and commerce, but also applies to agricultural and extractive industries and to all manufactured or natural products. Example, wines, grain, tobacco leaf, fruit cattle, minerals, mineral waters, beer, flowers, and flour. So this definition, which was not exclusively deals with the invention, but it deals with the broader scope of the industrial property, was given under Paris Convention. So the Paris Convention does not allow biological inventions as patentable subject matters. So the member states are given freedoms to define invention in their own national laws. So based on that, the TRIPS agreement, the TRIPS, the TRIPS agreement, it goes something beyond the Paris Agreement, Paris Convention, and give the definition of the patentability in the subject matter. So the TRIPS agreement said that the patents shall be available for any invention, whether products or process, in all field of technology, provided that they are new, involve inventive step, and are capable of industrial application. So according to the TRIPS agreement, three essential features are given in this. So for any patent, for any invention, it must be require patents that it must be a new one, and it must involve inventive step, and third, it must be capable of industrial application. So here again, there is a explicit definition of the invention is not given. So during the meantime, the national domestic laws, various countries passed their own laws with regarding to what comes under invention. But in the field of biotechnology, the US Supreme Court gave a landmark judgment in Diamond versus Chakrabarti case. In that case, where the judge stated that the patentable subject matter could include anything under the sun that is made by man. So the judge stated that the patentable subject matter could include anything under the sun that is made by the man. So in this case, the Supreme Court rejected the argument that an engineered bacterium being a life form was not patentable. So here also they rejected to give the patent to the biotechnology. So the US, after a broad and flexible approach towards granting biotechnology patent, so they subjugate to that Diamond versus Chakrabarti case. They easily encompass the higher life forms like genetically modified mice under the regime of the patents. In that case, the Canadian court, in another case, the same view arised in the Canadian courts. In the Canadian court, make a different view by saying that the genetically modified mice, it rejected the patentability. So, what is the criteria for patentability? So, the patent law gives three conditions to be fulfilled, being a patentable subject matter. If subject should want to give any patentability, then the subject must follow these three steps. One is novelty, second one is inventive step, and third one is industrial application. What is novelty? Again, this comes under a big debatable. The why you added the novelty under the definition of the patentability criteria, because to avoid the patent monopoly over something that is already existed in the public domain. But the difficulty faced in dealing with the biotechnology patents is varying definitions of the state of art or prior art in different countries. For example, UK, all matters which has at any time before the priority date of any invention been made available to the public by written or oral description or by use of in any way to be stated as the state of art. But the results would differ in the case of US or Australia, where mixed novelty criteria is applied. Mixed novelty criteria is applied with regarding to the state of art. So again, the novelty term itself becomes a debatable. And the second step is inventive step. So the inventive step, the test of inventive step is always with reference to the person skilled in the art. Here also another complication arises in the case of biotechnology inventions. If the traditional knowledge teaches that the oil extracted from the leaves of the plant have antiseptic effect, will the researcher who first identifies and separates the active ingredients be able to claim a patent limited to the isolated ingredient? Such isolated ingredients does fulfill the criteria of novelty, even if it is a part of traditional knowledge, because the traditional knowledge does not equivocally teach us the claimed invention, that is the isolated and purified active ingredient, but its inventiveness is disputable. If the prior art is interpreted as having no teaching, then making of such invention itself establishes its inventiveness. The so-called biopiracy. So there is an urgent need to open a question for the prior art base that would be instrumental to attack on the basis of the lack of inventive step. The third step which requires for patentability is industrial application. So many of the inventions, through fulfilling the novelty and inventive step criteria, fails to be patentable since there is no direct utility evidence. In such cases, the product is not new, but its new application in the field of medicine is claimed for patent. For example, if you consider a chemical product, X is patented for some non-medicinal use. Afterwards, a medical application of this compound is revealed. So first the compound X is patented for some non-medical use. After that, a medical application of this compound is revealed. In such case, the medical claim can be separately patented and is granted and a full term of new patent. So that is the issue before the concerning of to whom it give the patentability. Some exclusions also given to whom you can't be give patents. According to the TRIPS agreement, members may exclude from patentability inventions the prevention within their territory of the commercial exploitation if for the protection of public order, morality, including to protect human, animal, or plant life or health. So this comes under uh, if uh, if any invention which hampers the public order, morality, or health or life of the human, animal, or plant, then it merely because of this exploitation is prohibited by the law. So that means every member state is given free choice to apply the exclusion from the patentability. So there is no such type of obligatory. This was started especially the American. In America, American Patent Office, US Patent Office, USPTO, it granted the health of the plant, then it cannot be comes under the patentability. USPTO gave the patent to the transgenic mouse. So in this case, it stayed with this Diamond versus Chakrabarti case of 1980 concerning a genetically modified bacteria used for a degradation of hydrocarbons. At the same time, the European Union decision also gave some controversy covering this transgenic animal. They determined that whether an invention covering a transgenic animal was public order or morality. In that case, the Board of Appeal gave some guidelines. What the guidelines gave? First, it should be balancing on one hand the suffering of the animals and the risk of the environment, and on the other hand, the benefit of the mankind. United States patent also said that European Union also, if you must create some balancing on one hand, suffering the animals and the risk of the environment, on the hand, the benefit of the mankind. So depending upon the relevant weight, the of public order. So in the case of this Harvard mouse, the benefit for mankind prevailed because uh, cancer treatment tested for the cancer treatment. So it was benefit for the mankind. So patent was granted. Another important point should be considered in the case of patentability is it not always be enough to stop such invention from being worked. For example, human cloning. Almost all the patent laws expressly exclude human cloning from patentable subject matters. But there is no binding obligation on the researchers to stop research in the field if they choose to go ahead without applying for patent or bothering about obtaining one. So this is some controversy provisions are given. This is some controversy. This is some controversy provisions are given under this domestic laws. So based on that, very protect to grant the patentability to the biotechnology was very much discussable in the global arena. So some defenses are there in the patent law. That means till now, the law said that no patentability should be granted to the criteria which was given in the TRIPS agreement if it violates public order, morality, life of the human, animal, or plant disturbs. But the defense is also given. The TRIPS agreement provides for the exceptions to the patent rights. TRIPS agreement gives the members may provide limited exceptions to the exclusive rights conferred by the patent, provided that such exception do not unreasonably conflict with a normal exploitation of the patent and do not unreasonably prejudice the legitimate interest of the patent owner. At the same time, taking account of the legitimate interest of the third party. So that means the biotechnology inventions, three main types of defenses need to be provided. That is against innocent bystanders, second, to protect the farmer's rights, and third, to protect experimental defenses. So what is the innocent bystanders? For example, the biotechnology invention involves subject matter which has the ability to reproduce themselves, unlike any mechanical inventions. So with the existing system you are developing, there is a reproducing ability. So this is biotechnology. It is not a mechanical invention. So hence, even after taking due care of protecting the invention in a restricted area, it is possible, quite possible, that some patented life form or exactly similar one is produced at some other place. For example, there may be a variety of plant which may be genetically modified and duly patented. It is possible in nature that similar kind of mutation in gene can occur accidentally, and such mutant variety would exist same characteristics as the patented one. In that case, the innocent growers of such mutant variety should not be held responsible for patent infringement. The second one is farmers' rights. For centuries, farmers have been cultivating various plant varieties, and their efforts in selecting and promoting the best breed have made it possible to achieve today's quality products. Here, it is quite common in the farmers, they produce seeds from their crops only. They sometimes they are not buy, they are to they produce themselves. In that case, all the farmers have been growing the harvest in their fields and using it for consumption after saving the best seed for the next plantation. So in that case, you cannot call him as a patent infringer. Next, the third one is experimental defense. This is most achieve the broader goal of patenting because incentive to inventor and promotion of technological development is growing on. So many patentable inventions are based on some other inventions already patented. In biotechnology inventions, this trend is further enhanced. In order to the scientists continue to research and improve on the technology, it is must that they have provided an environment where they can work freely without the fear of allegations of patent infringement. So the biotechnology invention protection is a challenging task for the lawmakers and intellectual property petitioners. Next is the protection of genetic resources. With regarding to protection of genetic resources, there are three bodies were there which were established to deal with this exploitation of plant genetic resources. That is, first of all, what is the major issue with regarding to genetic resources? The major issue is how does the world compensate countries that have contributed valuable plant resources. For example, how many of you know that coffee is famous in Ethiopia? Historically, Ethiopia is the home for coffee plant. But whether the Ethiopia is shared any economic benefit? No. So these genetically resources should be protected. And the second controversy is major issues conservation of the diversity of life that exists on our planet. So these are the two issues which triggers the protection of genetic resources. So to deal with this genetic resources, protection of genetic resources, there are three bodies are existed. That is, one is Convention on Biological Diversity, and second one is International Undertaking on Plant Genetic Resources for Food and Agriculture, and the third one is International Treaty on Plant Genetic Resources in Food and Agriculture. So this CBD, Convention on Biological Diversity. The Convention on Biological Diversity was established in the year 1992 in the Earth Summit, which was held in Rio de Janeiro, Brazil, which is also famously known as the Rio Conference. It is also known as United Nations Environmental Programme. So in this program, the proposal for the establishment of Convention on Biological Diversity was happened. So based on that, it was established and it came into force on 1993 December. So what are the basic objectives of this Convention of Biological Diversity? So the objectives are, first one, conservation of biological diversity. Second one, sustainable use of its components. Third one, fair and equitable sharing of the benefits arising out of the utilization of genetic resources. So these are the three main objectives of Convention on Biological Diversity. So what are the provisions which deals with the Convention of Biological Diversity with regarding to intellectual property rights? So the provisions, first one is according to Article 8 of this CBD, Convention of Biological Diversity, there should be in situ conservation. So there is, in the case of biological diversity, conservation of biological diversity, there is two mechanisms exists: in situ conservation, ex situ conservation. In situ conservation means that is within the one gene or within the genome. It is limited. The area is limited for the conservation. But ex situ conservation, it is a vast outside also. For example, national park comes under the in situ. Biological park comes under ex situ. So this in situ conservation, what talks about this in situ conservation is nothing but when with regarding to the national legislation, they should respect, preserve, and maintain the knowledge, innovation, and practices of indigenous and local communities with regarding to this in situ conservation. So while dealing with the Convention of Biological Diversity, they are mostly focused on this in situ approach. In situ approach means they must maintain, respect, preserve, and innovative technology practices of indigenous and local communities. And the second provision which deals with IPR is Article 15, access to genetic resources. So recognizing the sovereign rights of the states over their natural resources, the authority to determine access to genetic resources rests with the national government and is subject to the national legislation. Whenever there is a in India also there is a debate between state subjects and national subjects, union subjects, state subjects, and concurrent subjects. So in that type of situations, always you should maintain this natural resources as the national legislation, national governments with hands of national governments. And third provision which deals with IPR is Article 16, access and to transfer of technology. This is yesterday also we are dealing with the technology transfer. So each contracting party of this CBD recognizes that technology include biotechnology, both access and to transfer of technology among contracting parties. And the next provision is Article 17, which talks with exchange of information. So the contracting parties shall facilitate the exchange of information from all public available sources relevant to the conservation and sustainable use of biological diversity, taking into account of the special needs of developing countries. So this is the main important exchange of information. Exchange of information in developing countries. And next provision is in technical and scientific cooperation. So this technical and scientific cooperation, this field of conservation and sustainable use of biological diversity, wherever necessary, through the appropriate international and national institutions. We have to promote this international technical and scientific cooperation. The next provision is Article 19, that is the handling of biotechnology and distribution of its benefits. So in this provision, it talks about the contracting parties shall take legislative, administrative, or policy measures inappropriate to provide the effective participation in biotechnological research by the contracting parties. So these are the provisions which of the Convention of Biological Diversity deal with the intellectual property rights. Next, there is another two bodies deals with this biotechnology. That is, the second one is International Undertaking on Plant Genetic Resources for. So this international undertaking is known as IU. This IU was adopted by the FAO, Food and Agriculture Organization. This is the UN's specialized body, United Nations specialized body, Food and Agriculture Organization. This Food and Agriculture Organization, make a conference in 1983, which its primary objective is to promote international harmony in matters regarding access to plant genetic resources for food and agriculture. So this undertaking first initially identifies the farmers' rights. It strikes the farmers' rights. There are three resolutions which were adopted by this FAO conference. The first resolution recognizes the plant breeders' rights according to the Union for the Protection of New Varieties Plants. So the undertaking and simultaneous recognition of the farmer rights, simultaneous recognition was given under this first resolution. The second resolution talks about farmers' rights. The third resolution, it talks about sovereign rights of nations over their genetic resources. So these are the main three resolutions passed by the Food and Agriculture Organization Conference. So first resolution talks with plant breeders' rights. Second resolution starts with the farmers' rights, and the third resolution deals with sovereign rights of nations over their genetic resources. But the somewhere the FAO commissioner thinks that you should have adopted some global action plan of action to protect the plant genetic resources for food and agriculture. To meet the needs of the conservation and promoting sustainable use of the plant genetic resources, they think that there is a urgent need of global action plan. So in 1993, this FAO commission, FAO commission, they asked that to draft a global plan of action. So this global plan of action and its implementation has been a subject of discussion under this international undertaking. The other key essential elements under the discussion in the negotiations include the scope and access to the plant genetic resources, the fair and equitable sharing of the benefits arising from the use of plant genetic resources, and the realization of farmers' rights. Basically, the countries have agreed that the undertaking should maintain a multilateral system of access and benefit sharing that meets the special needs of agriculture. In 1996, Food and Agriculture Organization convened a conference known as Leipzig. It is a place in Germany. So that is the Leipzig International Technical Conference on Plant Genetic Resources, where almost 150 countries formally adopted this Leipzig Declaration, that is the global plan of action. Next, third instrument is International Treaty on Plant Genetic Resources for Food and Agriculture. This was why? Because the plant genetic resources for food and agriculture are crucial because it feeds the world's population. So the raw material that farmers and plant breeders use to improve the quality and productivity of our crops. So the future of the agriculture depends on the international cooperation and open exchange of the crops and their genes of the farmers. No country is sufficient in itself. All depends on the crops and the genetic diversity within these crops from the other countries and regions. So after 1995, there are so many negotiations happen with regarding to Food and Agriculture Organization Conference. It adopts a international treaty on plant genetic resources on food and agriculture in 2001. It formally came in 2004, but the difference between IU and IT is the IT is legally binding treaty. It covers all plant genetic resources relevant for food and agriculture. And it also making some harmony with the Convention on Biological Diversity. The treaty also defines the plant genetic resources for food and agriculture as any genetic material of the plant origin of actual or potential value for food and agriculture. So, what is the objectives of the treaty? The objectives of the treaty are conservation and sustainable use of plant genetic resources for food and agriculture. The second one is fair and equitable sharing of benefits derived by the usage of that plant genetic resources for food and agriculture. So this recognizes the farmer's right to protect the traditional knowledge. What are the intellectual property related provisions in this international IU and IT? This IU and IT, especially Article 1 of IU, it talks about objective. The international undertaking on plant and variety genetic resources, it talks, the Article 1 talks about objective. So what is the objective of this undertaking? The objective is to ensure the plant genetic resources of economic and social interest, particularly for agriculture, will be explored, preserved, evaluated, and made available for plant breeding and scientific purposes. And again, Article 5 of this undertaking, it talks about availability of plant genetic resources. So this availability of plant genetic resources, it allows the international undertaking allows access to sample of such resources and to permit their export where the resources have been requested for the purposes of scientific research, plant breeding, or genetic resource conservation. So for these purposes, they are availability, there must be availability. The some national efforts in genetic resource protection, especially if you compare that the individual laws. So most of them are deal with the traditional knowledge, but especially to protect, every country wants to protect their own traditional knowledge, especially India, complying with this Convention of Biological Diversity 1992, they passed a act known as Biological Diversity Act. So the objective of this act, conservation of biological diversity, sustainable use of its component, and fair and equitable sharing of the benefits arising out of the use of biological resources knowledge. So this is the objective of the Indian Biological Diversity Act 2002. It protects the conservation of biological diversity. And the Andean community countries. Andean community countries is nothing but the countries which are supposed to have Andes range of mountains. So these countries are called Andean community countries. Bolivia, Colombia, Ecuador, Peru, Venezuela. So these are the Andean community countries. So these Andean community countries all passed their legislations that compiled with of biological diversity. Basically, the Convention of Biological Diversity, there is a two agreements were happened in between that within that Convention on Biological Diversity. One is Cartagena Protocol and another one is Nagoya Protocol. So simple. 1992, there is a Convention of Biological Diversity. So the policy was reviewed in 2002. It is Cartagena Protocol, and in 2012 it is again revised in Nagoya Protocol. So this is some legislations which give protection to the Convention of Biological Diversity. Next is protection of computer software. So there is a information revolution. What is information revolution means? The decade of 1980s, development of the information technology. So computer systems fastly growing in the software sector also. So during that time, the information revolution happens. There are three major mechanisms that offer to protect the software. Those are trade secrets, copyrights, and patents. Trade secret is any information in any information a business uses that is not generally disclosed. So the company by selling that software only in object code form. The copyright protects original works of the authorship against copying. Although the computer program has literal expression can be protected under copyright if ideas behind them embrace technical features, providing technical solutions, then the expression of those ideas could be patentable subject matter. But the major issue here is the distinction between patent protection and copyright is a vital in the software inventions. So the protection of computer software, on what basis the protection should be given, either based on the copyright or based on the patent. So there is a lot of discussions happens. Some countries favored somewhere, some countries favored somewhere. So some international dialogues also done. So protection of computer software under copyright. Question, what is the question? Whether the computer software protection should be granted under copyright law or patent law. For this, there is a Berne Convention, which was convened in 1886. So this Berne Convention was created irrelevant of the point of view they're qualifying as a literary marks if they are original intellectual creations. If that is the original intellectual creation, then it will be comes under the copyright protection. So what are the international and national norms concerning this copyright protection with regarding to computer system? So there are two instruments, that is TRIPS agreement and World Intellectual Property Copyright Treaty. These two again deal with that copyright protection. The TRIPS agreement clarifies that a computer program, whether in source or object code, while the whole WIPO copyright treaty, the WIPO copyright treaty expresses such protection applies to computer program, whatever may be made or form of their expression. So especially there is a thin line between Berne Convention, TRIPS agreement, and WIPO copyright treaty. So what do you mean by computer program? So computer program is a set of instructions expressed in words, codes, schemes, or in any other form, which is capable, when incorporated in a machine-readable medium, of causing a computer, an electronic or similar device having information processing capabilities to perform or achieve a particular task or result. So this comes under the definition of computer program. So the copyright protection of the computer program should also apply to the right of reproduction, right of distribution of copies, and the right to communication of the public. So the most important issue concerning the right of reproduction is the question of cases where it is justified to permit reproduction without the authorization of the right owner. So in that case, the Berne Convention, according to this Berne Convention, it said that national laws may permit reproduction of literary and artistic works, no problem. So the Berne Convention deals with two main rules under the computer software. One is right of distribution, and another one is right of communication. What is this right of distribution? That is the right to control not only the initial sale of copies of the work, but also subsequent distribution of such copies through the lending or renting, like that. So the right to communication is also gaining importance because new communication techniques are being developed which will enable high-speed digital delivery of works from data banks to individual users. The next, we conclude that who authorizes the works used or made by the computer. So for this, a report was published by the second committee of governmental experts on copyright problem arising from the use of computer for access to or the creation of works convened by the World Intellectual Property Organization along with the UNESCO in Paris in 1982. So the major findings of this report was there must be protected work into a computer system includes the reproduction of the work on a machine readable material support, and the output of the protected work from a computer should be protected under copyright law, irrespective of the form of the output. For example, as a hard copy printout, it can also give amending or modifying rules with regarding to their national legislations on account of the computer use of their protected works. So the general view which emerged from these studies in the no matter how sophisticated a computer, but the only tool is the author of a work produced by the aid of the computer is the person who conceived the product and who gave the programmer and the technician the instructions necessary to produce it. So that is very enough. The patenting of computer software, the protection gives under the gives protection, various domestic laws gives the protection to the computer software under patents. The first one is USA. Basically, the international agreements does not cooperate to give that computer software as a patents, but the USA is the one of the most favorable jurisdiction when it comes to the protection of computer related technology through patents. especially the US Supreme Court. Yes, in US also there is no legislation with regarding to this protection of computer software, but the Supreme Court of the US, it decides that the software consists essentially of mathematical algorithms and were thus not patentable. Okay, but this view also upheld by the US Supreme Court in uh, Gottschalk versus Benson, Parker versus Fluke. But there is a transformation phase between 1970 to 80. The computer industry developed rapidly. So during that time, the US Patent Office acting as a repository for the prior art of the software application. So in 1981, there is a case of Diamond versus Dare. The US Supreme Court, it overruled, ordered the US Patent Office to grant a patent on an invention, even though a substantial part of invention consists of a computer program that used well-known formulae for calculating the time when rubber was cured and the mold could be opened. So that is the Supreme Court stated in this case the invention was not merely a mathematical algorithm, but a process of molding rubber, which were the therefore patentable. So the first time US Patent Office develops or gives this license to the software patentability. Later, the European Patent Convention. The European Patent Convention, it excludes discoveries, scientific theories, and mathematical books, aesthetic creations, schemes, rules, and methods for performing mental acts, playing games, or doing business, and programs of the computers, presentations of information from patentability. So these all should be excluded from the patentability. But itself exclude patentability of the subject matter of activities referred in the provision only to the extent to the which a European patent application or European patent relates to such subject matter or activities. It not extended its wings to the other jurisdiction. It only extended its wings to the European Union only. So, according the European Union also disclaims with regarding to this, giving this patentability to the computer software. But 1986, the European Patent Office started granting patents that directed to computer programs, but presented in the guise of process claims, typically computer program. So the computer programs are open to patenting to the extent that they provide a technical contribution to the prior art. So the case law, again, in the European Union also, the Board of Appeal, it provided computer program can be reduced a memory access time, a better control of a robotic arm, or an improved reception for the decoding of a radio signal. This all comes under computer program. It can be patentable. And the third country which provides its domestic legislation with regard to protection of computer software under patents, that is Japan. Obviously, Japan is the universal requirement of novelty and non-obviousness. This Japan is very fast-growing country. In that time, 1980s, the technology is its peak level. So in that time, along with this novelty and inventive steps, the Japan also also wants patents can be granted on anything that is creation of a technical ideas utilizing the natural laws. So the software and business methods patents are concerned, this means that patents can be granted where an invention is achieved through the concrete use of hardware resources. So according to this, they gave patentability to the computer system. What about China? China Patent Office initially from the day one it rejects the software related applications on the ground that there are rules and methods for mental activities that are not patentable as prescribed their own patent law. So they are not treated these computer softwares under the patents. What about India? India, they are already passed the Patent Amendment Bill 2005, yet to be become the act. But later there is a ordinance came. So they are also clearly, vehemently said that computer program per se is not patentable. That means the computer program uh, alone is not a patentable. So like Japan, we should add something else. So in India also, what patentable, whether the computer system is protected under patent or not is a very much debatable issue, not fully finalized. So the drafting of application for software patents. So what issues should you concern with regarding to drafting application? First one is patentability issue. Because while making an application for software with regarding to patents, there is a see software patents including business methods patents and internet related patents have become the focus due to this software industry and IP protection. So many of the software patents have been granted by this um, European Patent Office or US Patent Office or Japan Patent Office. There have been many lawsuits regarding patent infringement. So software contains an abstract manifestation rather than clear description. In many cases, flowcharts, pseudocode, and other graphical methods are not enough to illustrate the unique function of the software. So, for the successful prosecution of the software related inventions, is heavily dependent upon how well the specification and claims of the patent are construed and drafted. So, what should we make in our consideration that for the drafting of the claims? For drafting of claim, what should we think? We should different national patent office have varied standards and norms in recognizing, computing, implementing uh, inventions for patentability. This US patent office permits the broadest possible scope for a software patent, focusing on tangible rather than the technical contribution of the invention. In fact, there is no requirement in the US Patent Office that computer related inventions have a technical character or solve a technical problem. So, the business method itself is patentable if it merely produces a useful, concrete, and tangible result. But with respect to European Patent Office and Japan Patent Office, the US Patent Office adopts a more liberal approach in the case of business methods. The European Patent Office has the highest technical nature requirement. In other words, the technical character with a technical contribution is essential to a statutory invention in the European Patent Office. So this technical contribution should be non-obvious. So the technical apparatus which was used by the contribution of that computer system. So the European Patent Office clearly tells that it is not enough. So the it would not be protected by the patents in European Patent Office because it would lack technical character even if its scheme runs on a computer. So because of that, but the scheme patentable in US Patent Office if it fulfills requirements that produce a useful, concrete, and tangible result. But in the case of European Patent Office, it is not enough because it wants the technical nature of the requirement. So the Japan Patent Office, midway the Japan, they adopted the middle road. We'll comparing to the US Patent Office and European Patent Office. What Japan adopted is, if you want to protect a computer software, then Japan Patent Office requires a technical aspect that can be achieved by drafting a patent claim to specify a computer or by combining a process with a technical apparatus. According to this application of this JPO, Japan Patent Office, both the US Patent Office and European Patent Office mixing of the provisions which suits the Japan Patent Office, they were adopted. Some of the common claiming strategies are there. One is considering of statutory invention issues. Basically, the first goal while framing the claim should be the patentability test, especially in the area of technology. And the second step is built in response for any possible rejection. So while you drafting a patent application, so built in response in possible rejections. So you should give the fact that software patents enjoy relatively broad scope compared to the technological areas of patents. The third, diversity of claims in scope. That means you should include as much as diversity in the claim as possible, because this helps to vary the scope of the software claims among narrow, medium, and broad scope. So by drafting claims of at least two different scopes of protection, that is, the patent claims will be harder to invalidate as a whole while infringing the claims of the maximized. And the fourth one is use of different claim formats. That means every national or every application with regard to that national application have their own strengths and limitations. So you have to think before twice while drafting the software patent, because use different claim formats. It will provide a wide variety of claim formats which will maximize the enforceability of patent by covering various aspects of invention. The next one is use minimum expressions that can lead a narrow interpretation. If an interpretation gives a narrow concept, then you should avoid the avoidance of undue limitation of the claim. It is desirable to minimize the possibility that a court will consider particular element was being essential or not. And the other one is maximization of lateral infringement. So there is a doctrine of equivalence. What this doctrine of equivalence is, if the accused device or method is sufficiently similar, though not identical to the one defined in claims, then courts will consider it infringed because it is equivalent to the claimed invention. So while if anyone wants to apply for the patent infringement, So maximum literally infringements you should tell that doctrine of equivalence. You should apply through the doctrine of equivalence. Next, and one more important is uh, you should avoid the classification as business methods, because as such form patentable subject matter, the especially the European Patent Office has been conservative in the examination of business method inventions. So this method of patents granted by the US are normally selected for second level of review. In that case, you should avoid the classification as a business methods. The last but not least, you must consideration for royalty base and licensing, because drafting a claim requires the consideration for commercial aspect of the patented technology. So the future royalty base of an invention will improve if an invention includes a method of manufacture claim, since the royalty will be higher for the overall manufacturing process. So these are the some common strategies. Some individual strategies also there with regarding to US, with regarding to Britain, with regard to Japanese, they're almost similar. What the final topic is practical effects to software patents, because this patenting software has become popular. So this is difficult to quantify. So many companies, they filed this patent infringement applications against one another. Somehow they're succeeded. So most large software companies have cross-licensing agreement in which each agrees not to sue other over patent agreement, because they want to avoid this type of legislation which were infringes their right to uh, do scientific investigation, scientific research. So in that case, what will happen is most of these top technic software companies, they're avoiding not to sue. They're making mutual agreement with other company. No problem, even though if you are infringing. For example, Microsoft has agreements with IBM or Autodesk or Cisco. Microsoft agreed to share with Sun, even though they are direct competitors. And also, sometimes if you see the Autodesk is the very few patents, even though the Microsoft makes some agreements with Autodesk, because they don't want to make this infringement complaints, because it will further devastate the advancement of the technology. So in practice, software engineers rarely search patent bases and applications looking for new inventions, because they lack the inventive step in many software patents. And second, the obscure language which software patents are described. And third one is the risk of being assessed for triple damages for knowingly infringing one. So these are the main concerns with regarding to the software engineers with regarding to application of the patents. So for this, we are completed this uh, session of patent in new areas. If you have any doubts, then you can ask. Anjali Singh, is everything okay?
Sir, I got a question.
Okay. You
Sir,
want to ask or
regarding
if you want to
construct,
type regarding?
I think she is having some doubts, maybe.
Yes, yes,
Regarding
yes.
no, sir. Regarding cancer drugs, what is the patent? Is it possible for the government without the authority of the inventor? They can issue the drug to everyone.
Yes, that is the main step. Now we are discussing. See, if the purpose of uh, greater people, for example, if you see, uh, leave that cancer drug. If, for example, if you see that recently we are distributing our COVID drugs to the COVID vaccine to the other countries with free of cost. In that case, what is the national uh, health will play more role. In that case, what will happen is sometimes uh, if you find out on cancer drug, but you are making it high price, in that case, what the government should do? The government should allow to infringe that your uh, patent, but it is all depends on the government. If it is useful for the government, the people, the public at large, then the government can make. Finally, you see, the government is at the stage to issue the patentability. So if you are making some high quality, then government should not. So that is, you should not made for the commercial exploitation, but government can do that.
Okay, sir. Thank you, sir.
Okay,
Yeah,
sir, Krishna
okay.
sir.
Thank you. Yeah, thank you, Mr. Ramanamurthy, and the students. Monday onwards, another course will start. There is a project also. I think you can inform to your friends also. Please, thank you. Thank you, everyone. We are closing it.
Thank you, sir.